Welcome to the Great Trials Podcast. This is Steve Lowry with Yvonne Godfrey. Yvonne, it's been a little bit of time since we've talked.
It has. We told people we'd be slowing down on the new episodes a little bit, but we
Boy, did we
we
mean
really
it.
slowed down.
Yeah, exactly. We
We really
we
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 really
we
followed through on that slowing down.
yes. I mean, yeah, nobody can claim that we weren't being honest with them, and we just man, we really hit a slow patch. But we are going to try and get more podcasts scheduled so we can at least be getting out some new episodes. But anyways, it's good to be back, and usually you're in Atlanta, Vaughn. Usually you're a long ways away, but today you're directly downstairs from me.
That's right. We are in the same building, and we picked so that's fun. That's a fun way to sort of kick things up again in 2024. And we have a very interesting, very different from our kind of usual case to talk about. So it'll be a fun one.
Yeah, no, and a very exciting one. So let me go ahead and introduce our guest. Our guest is Jordan Strokovsky. I know I'm screwing that up, Jordan. I'm sorry.
Perfect.
Strokovsky. And Jordan is with Strokovsky LLC. You can look him up at actionafterinjury.com. That's his website. Jordan is based out of Philadelphia, Pennsylvania. And has had just a tremendous verdict on a med mal case with some really interesting twists, especially one that we'll get into right at the beginning, which is that he worked so hard on this medical malpractice case that the defense admitted liability right from the beginning, which for our listeners who try med mal cases, that is almost never done. I've tried a bunch of them. I've never had that happen.
Not right from the beginning, but like the first day of trial, right?
Yeah, right. Yeah, no, and I should have been clear about that. I mean, it was after 4.5 years of hard work by Jordan on the case, so it's not like they just rolled over immediately. He had to work his ass off for a long time. And then they came into the courtroom and, as a strategic move, decided to admit liability. But Jordan, let me tell everybody a little bit about you. So Jordan, as I said, is from Philadelphia and went to Temple University undergrad, which is interesting because the defendant in this case was Temple University Hospital. So Jordan, I'm assuming, is very familiar with that hospital. And then went on to the Widener University or Widener Law School. Widener. God, man, I knew I'm going to screw up the pronunciation. So Widener School of Law at Delaware University, where he graduated #1 in his class, the valedictorian. And I actually watched Jordan's his graduation speech, after which the governor said that he would never want to follow Jordan again, giving a speech, and with a great theme. Jordan's theme throughout was "Look how far we've come." And I got to say, for somebody who was brand new out of law school, very polished, very effective, and just came across as somebody who'd been doing this thing for years. So that's where he got his law degree. He then went on and got his LLM in trial advocacy, again from Temple University. And I wonder if Temple is just regretting the fact that they helped him become a lawyer, now that he went out and got this verdict. But Jordan has been practicing law in all kinds of cases, not only medical malpractice, but in product liability. And I saw that you did some volunteer work for victims of sex abuse, and did a lot of other pro bono and volunteer work. He's on the board of directors of the Pennsylvania Association of Justice, and has just been doing really great work. And so we're happy to have Jordan on the show. So welcome, Jordan.
Thank you. It's an honor to be here.
Yeah. It's this case. I mean, as I was reading it, I was just like, wow. I couldn't believe it. But let me just give a quick background of the case. And Jordan, where I've made some mistakes, you can go ahead and correct me. But this case involved, as I've said, Temple University Hospital and a doctor by the name of Matthew Lori, who is an orthopedic surgeon there. And Jordan's client was Eddie Parks. Eddie, on December 30th of 2018, was assaulted and kicked in the leg. And I guess unbeknownst, or maybe not unbeknownst, but his knee became dislocated there, and his popliteal artery was transected. And essentially, when he came into the hospital, he was claiming that his foot felt numb. He had 10 out of 10 pain. The doctors did actually consider compartment syndrome, which is essentially because of swelling, the blood supply is cut off, but they didn't diagnose it soon enough. And long story short is that Eddie ended up spending 39 days in the hospital, went through 6 different debridement procedures of necrotic tissue until they finally were not able to save Eddie's leg, and had to do a through the knee amputation, which is, I mean, it usually hear of above the knee or below the knee amputation. They actually did a through the knee amputation for the purposes of fitting for prosthetics. My understanding is that that is similar to an above the knee amputation, and harder to get a good prosthetic, and harder to treat. Eddie was 27 years old. He was a certified nursing assistant, had a girlfriend, and had just received news that he was going to be a father, and loved to cook. And as Jordan said in his opening statement, that on January 22nd of 2019, as he was being wheeled into the operating room, everything changed because he lost his leg. And just a catastrophic injury. And the really there's a lot of interesting things here, but the thing that is so shocking here is that on the day of trial, which was 4.5 years after the case had been filed. So this, if I remember right, the verdict came out on May 9 of 2023. So May of 2023 is when the trial was. The defendants, the hospital, and the doctor admitted liability, admitted that they didn't diagnose the artery being transected, and that was the reason that Eddie lost his leg. So I guess I'll start there, Jordan. When you came to trial, was your expectation to be trying a full 3-week case, proving up liability, or did you have word that they were going to admit liability?
I had word about a week before trial that they were going to admit liability. So I was spending months and months and months working up, my opening and my case, focusing on liability. And then I got a call saying, for Dr. Lerai, at least, we're going to admit liability. And I even remember thinking, well, let me think that through. If I'm okay with that, it's like, it's nothing to be okay about. We're admitting liability. And then they also wanted me to release some of the other physicians and a physician's assistant involved, which I did after they said Dr. Lerai would stipulate the liability.
And I guess Dr. Lerai was or he was an agent or an employee of the hospital.
Right.
Okay. Yeah.
It's so funny because I read the complaint first. Like typically, like when I'm prepping for the episode, I go somewhat in chronological order, unless there's like a press or news story or something like you had where I read that first. But so reading the complaint,
but
and
by
I
the way,
didn't realize,
don't. I start at the end. I look at the verdict first, and then I go backwards. But
and then you
go
backwards.
ahead. Yeah. Go ahead.
Well, I just was going to say that in reading it, Steve, right? Like I'm automatically thinking about our cases and the stuff you have to fight in med-mal over and over again. And like, what's the causation argument? Are they going to be? Are they going to say it was going to result in the injury would have had to result in an amputation anyway? Just sort of thinking through like how it was going to play out, because it's just, that's what you always have to do in med-mals. There's always a fight over the standard of care, a fight over the proximate cause. Like, so I was so shocked when I got to, basically the transcripts of opening and read that liability had been admitted. I was like, what? I mean, I can't imagine how you felt, Jordan, just knowing how intense that work is with the experts. and the depositions to kind of, tee up all those issues about standard of care and causation, to then not have any of that be part of the trial. I just can't imagine how that feels. There's not really a question in there other than
Yeah.
I just like how how do you kind of like, I mean, I guess you kind of had a heads up, but like, how do you just retool everything? How do you prep your client for that?
Sure. So, yeah, I mean, as spending months and months and months preparing the liability aspect, and then to be told, we're going to admit liability, I definitely felt like the winds were taken out of my sail, so to speak.
Right.
I'm kind of like, now what? Like
Yeah.
everything about my case has changed, and frankly, I really felt like I had a great liability cases, the more and more I spent, preparing for trial. And I was like, wow, they kind of just took all the juice that I had going for me. And I had some surprises for their expert witnesses too, that I don't think they were aware of. And I really thought the jury would have lost all credibility, which I think would have also helped with the damages aspect of the case. And so, yeah, when I heard about it, you have to, I think it would have been really brazen of me to say, no, I'm not going to allow you to do this, or I'm still going to try my case, or
Right.
bring in the other doctors. I'm not done with them. Like, we're going to hold them accountable as well. It's, somebody gives you a win like that, you really don't have much of a choice but to take it. But I was really thinking for a day or so, like, wow, this is actually quite effective. Because before, in my mind, it's like, these guys, I'm gonna get them for 50 million. I mean, that might be crazy,
Right.
but that was my mindset. Like, they're gonna pay for this. And then my whole strategy had to change. But I mean, the damages obviously in this case were immense. So fortunately, the trial was postponed a week because all of my liability experts were slated to come in, and all my damages experts were slated to come the following week. So fortunately, the court said, okay, you have a week before we'll do jury selection. So that allowed me enough time to pivot and reorganize everything about my case.
Right. And I guess,
Gotcha.
I mean, there must have been some sense when you were doing the expert depositions of the defense that things were going well. I mean, I'm not sure the defense counsel or the other side would ever admit to you why they admitted liability, other than the fact that they thought it strategically helped them. But there must have been things going well for you as you were working up the case for them to say, we're going to be better off just admitting liability.
Sure. And so in this case, I took depositions of the ER team that initially treated Eddie, and then the ortho team that treated him. And just based off their statements, their observations, it really got to a point where either all of them were going to be at fault at trial, or at least one of them. Because
Right.
you have an attending saying, well, it's my expectation that if a resident can't examine the knee, that they're going to tell me and I'm going to examine the knee. Or if a resident has a knee dislocation on their differential diagnosis, yes, of course, that's something I want to know about. And, well, how about here, doctor? Well, no, I wasn't aware of any of these issues. And then I deposed the resident, and he goes, well, no, I had a knee dislocation on my differential. Did you tell anybody? Well, yeah, I think I would have told my team. Or, I couldn't touch his knee. Would you have told people? Yeah, I would have told people that. And then even the ER team, he was first seen by a physician's assistant, who also, he testified, he's in so much pain, I couldn't touch his knee. And a wrinkle with him, well, actually, there were two. One was the initial medical records I received had really no documentation from him. So it kind of looked like he didn't see him at all or even try to touch him. And then I think a few days before his deposition, after the lawsuit was filed, I received a note, or, showing findings from his examination. I was like, well, where did this, how did this come about? In his deposition, I think he said something to the effect of, I got a call from medical records. They said I didn't finish my note. So I went in and finished the note. I was like, when was this?
After you filed the lawsuit?
Yes, after I filed the lawsuit. And I even pressed a little bit more, like, well, how'd you get this notice? Let me see this email. I remember receiving it, And I think it was to the effect of defense counsel advises, go in and enter your note or something to that effect. So I thought that was a bit peculiar. I haven't seen that one before. But also, he's saying, I tried touching his knee. I tried touching his knee. And my client says he never tried touching my knee. And then I deposed this nurse. And most of the time, nurses or medical professionals in general, they don't remember much in these cases. She actually said, do you remember, what happened? And she said, I remember he had his jeans on. Okay, was the pant leg rolled up above his knee or something? No, the pant leg was normal, or it was rolled below his knee. So the guy's in jeans. It's impossible to examine this guy's knee. And the physician's assistant actually put in a discharge notice 45 minutes after he came to the hospital. They're trying to send him home. And my client just advocated for himself. I can't walk. I can't feel my leg. I'm in a ton of pain. I'm not seeking pills. Like, I need to be seen. Like, this is serious. So I definitely thought there was a delay with the ER team, but the ortho team, they really made so many mistakes. They made mistakes in the several hours prior to performing the fasciotomy and in figuring out what was the underlying cause of compartment syndrome, because usually you get a traumatic injury. You have a horrible bone break, or you fall from a great height. Here there really wasn't, you kicked in the leg. You don't really think, oh, you get compartment syndrome, unless what could be another mechanism, a knee dislocation, because knee dislocations typically pop back into place, and the popliteal artery is situated right behind the knee. And it's known that it's a serious emergency that must be addressed, because you have to rule out a popliteal artery injury, or else you're going to lose the leg. So then you have the attending that's doing the surgery for the fasciotomy. And he notices that the knee is unstable. He notices a large hematoma, a pool of blood right below where the popliteal artery would be, but he doesn't really explore it. He just makes a note, there might be a knee dislocation here, and allegedly told his team, keep a close eye on this guy. And he headed home. And then the next thing you know, several hours later, his leg is completely cold and essentially dead. And then that's where they finally, get vascular involved and try to save his leg. But sadly, it's too late.
So the timeline that we're talking about in order to save his leg is hours that they needed to, or less than that, to act in order to repair the artery. Is that how quickly they should have acted?
Yeah, well, when they did the fasciotomy, so that was probably about 6 hours, give or take, after the initial injury. They noted his muscle was still relatively healthy. So even then, at the time of surgery, they could have saved his leg. And there are even some opportunities after surgery. But by the time they started noticing anything, that was about 12 hours after the fact. And they were pretty slow to react even when they saw it. And it took a few more hours for them to conclusively have a plan or take him back for surgery to try to save his leg. So yeah, action could have been taken within the first few hours. The leg still could have been saved several hours after that, and even a few hours after that. But sadly, just there's so many delays, it was ridiculous.
And so all of these debridements or procedures that he was going through, I think it was 6 of them. And I mean, so that happened on December 30th to the 31st. He doesn't actually have his leg amputated until January 22nd. So we're talking 3 weeks later. So during that time, they're basically doing all these debridements on him, but at the same time realizing that they aren't going to be able to save the leg, or what's happening there.
Sure. So it was a very trying time for him, obviously. He's getting not the best communication, or at least from his perspective. They seem to be optimistic that they can save the leg. Let's do these debridements. And who knows if behind closed doors, they're thinking, well, it's going to be really tough to save this leg. But for 3 weeks, yeah, he's basically stuck in a hospital bed. He has an external fixator on. His leg from the fasciotomies is just completely sliced open. It's quite gruesome.
By the way, Jordan sent us some photos, and they are pretty horrific photos, especially when you're not expecting them.
there are photos in the complaint, and I have to say that I was like, wow, I've really come a long way, because my first year practicing, I think I probably would have been sick, because that was like the hardest part of the job for me when I first started, was like the pictures. I mean, they're an important part of the story because words can't really describe it, but it is, I can't even describe it now, but it is really kind of horror movie. Like at one point, Jordan, you compared it to a butcher shop, I think, in your
Yeah.
closing. And it really is like that. I mean, it's unreal to think that this man was laying there for days with a leg like that. I mean, just cut open. I really can't even imagine. I didn't even think that happened, to be honest.
Yeah.
And
Not for an extended period of time. I mean, is it just like that for an extended period of time, for those days while they're trying to maybe save the leg?
Yes. So usually with a fasciotomy, they'll close the wound up soon after. But here, because they kept going back in and there was an infection, it was basically out and open like that in a horrific manner for 21 days. And he was getting an infection because of that, and it was causing him to have delusions. And at one point, they even had to put restraints on him. So he's also, being restrained. And I think I even told the jury that, like, imagine like you go into the hospital and they're supposed to fix you. And then the next thing you know, you wake up and your leg is in that state, and you're hallucinating, and you're restrained to the bed. And they're telling you they're going to save your leg, but then they say, well, you're going to die if we don't amputate the leg.
Yeah. It's like, I've never seen the Saw movies because I'm too scared, but like, I feel like that's what it's like.
Yeah.
I mean, it's horrible. Unreal. Anyway, sorry, I didn't mean to derail us, but
no, I mean, the pictures are, they're breathtaking. It's definitely difficult. I should have told everybody, and usually I do this, is I didn't even tell them what your verdict was, Jordan. I'm sorry. So the verdict was a total, the initial verdict was $25,993,331. That was made up of 11.2 million of past non-economic damages, 8.8 million of future non-economic damages, and then 5.993 and some change of future medical expenses. There was no claim for lost wages or lost earning capacity. And then what was added to that for the judgment was what's called delay damages of $3,741,204, and then post-judgment interest of $646,000 for a total judgment of $30,381,145.60. And that was the first thing I saw when I looked at your judgment there, Jordan, is I'm not familiar with what delay damages are. What does that just mean, that they had the opportunity to settle the case and didn't, and then there's some sort of something that's added to it because of that?
Yeah, it's basically if there's a verdict and any prior offers by the defense are just nowhere near what the verdict is, then they have to pay a certain level of interest.
Okay.
And here their highest offer was $3 million. So, which really was, I think, within a month of trial. So, yeah, it wasn't close.
Right. Okay. So it'd be similar to like an offer of judgment, offer of settlement type thing that we have in Georgia, where if you beat it by 100, your offer by 125%, you get attorney's fees, costs, and things like that.
It's really impressive when you think about the amount of that verdict, considering that liability was admitted. I mean, we talk about that a lot, usually not in the med mal context of that being a strategic decision. And then, you keep out a lot of the egregious facts that might get the jury worked up. Although, as I'm sure we'll talk about, there's probably some other stuff in the defense's closing and sort of the positions they took in the case that probably got the jury worked up anyway. But while we're talking about the verdict, I did think it was interesting, and it's going to kind of tie in, I'm sure, with what we'll talk about later in terms of the post-trial stuff. But did I read correctly that the the defendants are the ones who wanted a year by year, the jury to fill out an amount that it was awarding for each year of the life expectancy?
Yes. So that is standard for medical malpractice cases. We just have a weird state law, which basically says for future payments, you're supposed to itemize it by year. But the parties
Okay.
can still agree, and you can put in a line for a lump sum. I would have been fine with either method, but they insisted on having the line by line for each year.
Got it.
So then in that case, your economist basically comes in and testifies as what each year is going to be, and then that's what the jury. I mean, because they basically gave you what you asked for in that respect, right? I think you asked for $6 million in future medical expenses, and I think it was like 993,000. So it's basically six million.
Yeah, the jury actually paid every penny that was on that we asked for. And you're exactly right in that our economist comes up and will give the general number, but we'll also show a demonstrative of what the amount is for each year. And then there was the defense tried making a big issue of that, which was respectfully preposterous. Basically making the argument, well, hey, we decided not to call our own economist, or we decided not to make our own demonstrative, so we think the jury should figure out these complex calculations by year and just wing it, which made no sense at all.
No, I mean, come on. People use tip calculators, so like, come
exactly. on. This is jumping ahead, but in Jordan's rebuttal, I think the defense lawyer had gone through basically what he thought the calculations of future medical expenses should be, and I think it was maybe $1.5 million or something like that. And I don't remember your defense counsel's name, but you were like, well, great job by Mr. Whatever. Without an economist, he's just coming up with it on his own, and you're just supposed to trust him. I thought that was
yeah.
I thought that was great.
Thanks. Yeah, that got me pretty heated.
Yeah.
That came across a little bit in the transcript.
Right. Yeah, exactly.
I mean, I kept it cool for most of the trial, but yeah, essentially what he did was, we have the economists, they base it off the numbers from the life care planners, and there's a real formula and science to it. And for whatever reason, they decided not to call their economists. I think it may have been because, again, kind of with the theme I was noticing from the defense, seemed like kind of let's nickel and dime this man every opportunity we get. So the calculation or the formula that their economists used in 2021 was favorable to them. That, like, you base it off certain percentages based off what the index is for a certain year of certain categories. But the case stalled for a year or two because of COVID. So when the supplemental reports came in 2023, he actually changed his formula a little bit, because if he used the same formula that he did in 2021, the number would actually be higher. Right. So my expert explained a little bit of that, and I'm not sure if that was the reason why they decided not to even call their economist. But basically what the defense attorney was trying to argue was, well, we have all these projections for prosthetics and care and blah, 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 blah. But in 2022, he said this to one of my experts, isn't it true that there was only $10,000 in medical expenses or some number like that? And I really, to this day, have no idea where he got those numbers. And so he basically, during lunch or the break we had before closing, on an easel, just took that $10,000 from 2022 and basically explained to the jury, well, yeah, they say he's going to need XYZ or $1 million this year or 500,000 that year. But in reality, let's just base it off 2022 or 2021, where it's $10,000. So really $10,000 a year over the next, 44 years, we're looking at $500,000 or something like that. And yeah, I was pretty infuriated because A, I have no idea where he got that $10,000 number. B, I think that number, if he did find one, would have been maybe like a Medicare type number for the bill, which you can't really bring up in.
Right.
Right.
One thing I did do to kind of combat that when I saw him driving that point home with my experts $10,000 a year, was I went to one of their experts and I was like, isn't it true that, Eddie had 3 socket replacements in 2022? Yes. And isn't it true that a socket replacement is, I don't know the exact number, 50,000 or 70,000? Yes. So then one point I made, like, so even by his own math, he's saying $10,000, but their own expert said he got 3 socket replacements, 50,000, 70,000, whatever they are. But we know it's a lot more than the 10,000. It just made no sense to me. And yeah, I take a lot of pride in keeping my cool, but that was just something I had to get a little bit heated for.
Yeah. I mean, I think it ended up working out well for you because I think you did object when it happened, and the judge, who seemed to kind of for the most part, let the lawyers just argue the case. But, the judge had basically just said, it's closing. You can address it in rebuttal. But, in my mind, I was sort of like, if he's like throwing out numbers for medical expenses, that's not really that's not coming from an expert's testimony. That's really not closing. It's really not just argument. But at the same time, I think it had to serve you well, because what you were able to stand up and say in response to that, not to mention the fact that he's throwing out numbers like $8,000, $10,000, which just is insulting. I mean, anybody
Right.
who's seen their own medical bill for like a physical knows that that's a ridiculous number. So even though I don't think he really should have been allowed to say it, I think it worked out well that he did say it.
Yeah. Well, and I will say, one thing I loved about how you came back at that was, you basically said they were trying to take advantage of the fact that he didn't like going to the hospital. And you can understand why Eddie wouldn't want to go to the hospital, because the last time he had gone, when his knee was hurt, they completely screwed up, and ended up taking his leg. So I think I can imagine why a guy like that wouldn't, want to think that, hey, let's go to the hospital, because that's not a place where good things have happened for him.
Sure.
Well, let's go. Let's back up a little bit, and I do want to talk about this other thing that. So, and I guess we should let the listeners know, after you got the verdict, the they then brought in, from what I understand, a new group of lawyers, or several groups of lawyers, and they moved for a remittitor, but it's under a statute that is specific to Pennsylvania, or which is the Medical Care Availability and Reduction of Error Act. And essentially, under that act, I guess if the judge feels like that this verdict was excessive, or would somehow impair the delivery of medical care in that community, then the judge can reduce the verdict. And so they made a motion under this act to try to reduce your verdict. I didn't actually get through to see what they were trying to reduce your verdict to, but I will say, I did not read the whole judge's order. I read part of it, but it was a 52-page order that the judge wrote, basically going through and excoriating them about all the misrepresentations they made, how they, basically were not telling how the trial had actually happened, and just took them apart. And by the way, we should tell our listeners, which is another, just, not only did they admit liability, but they didn't appeal this case, other than what I just said, and they paid the verdict, from what I understand. Is that right, Jordan?
That's right.
So, but tell us a little bit about this remittitor that they tried to file under this Pennsylvania statute.
Sure. So the first point that you mentioned, whether or not the verdict is excessive, that's probably the same analysis you'll see nationwide.
Right.
The second argument is where things got a little, again, it was a bit peculiar. It was a peculiar argument to see. In fact, most people haven't ever encountered this argument. And the provision under MCARE, talking about whether or not this will harm the community, or harm the ability to get medical care in the community, that may very well be unconstitutional if a verdict were ever reduced because of that. But there's basically no case law on it. And really, if it ever were to be applied in theory, we're talking about maybe a rural physician who maybe gets hit with a $50 million verdict and only has $1 million in coverage. And hey, if I have to pay this, I'm going out of business, and there's nobody else to treat this rural community within 100 miles. People are going to suffer.
Right.
So here, they gave a very general affidavit saying, the community is going to be harmed, our hospital is going to be harmed if we have to pay this. And not only did I find it peculiar because it was very broad, there were no actual specifics, but literally in the letter that the defendant sent me, where they admitted that they said they're going to admit liability, in that letter they note that they have $85 million in insurance coverage.
Okay.
So part of me is like, how are you truly going to be harmed so much where this man who actually was harmed, you're trying to erase his verdict, his just verdict, in a case where you have $85 million of insurance? It seemed crazy, frankly. But yeah, there was a big stir about it. I mean, the legal community, it was that type of argument was featured in the Legal Intelligencer a few times, and defense attorneys in the med mal bar were saying, "Oh yeah, it's a really good argument." But
Yeah.
fortunately, it was not a really good argument.
Did you do all that? I know you're kind of like, I think you said this, maybe it might have been one of the news articles after, about, sort of, this is why you do what you do, and your ability to represent your client and go against the big guys. But so did you end up bringing anybody in to help you with kind of the appellate issues in this, or did you handle all the briefing and stuff yourself too for this kind of novel argument?
So I did everything myself. Just got in early, but thankfully, again, the arguments were not really that difficult to come back.
Yeah.
When I read the initial brief, I was not that intimidated.
Yeah.
Just had to get back to work. But I will say, right, the oral argument for the post-trial motion, that really was a spectacle. Because Steve, as you mentioned, there were two big law firms that were added to the case. So there are 3 law firms total. And I just had a feeling at this oral argument, something different is going to happen to this oral argument today. So I show up about 20 minutes early, and I'm by myself, and I walk into this courtroom, and there are about 20 people in suits there, about a dozen attorneys, almost 10 what seem to be hospital executives, and a reporter for the local news or legal journal, the Legal Intelligencer. And I was just like, wow, this really is a spectacle. This really is quite a show of force. But then there's also a part of me that was kind of smiling inside, like, wow, this is why, plaintiff lawyers do what we do. Like,
yeah,
kind of like David versus Goliath. But in my mind, it might be cheesy that I actually thought this. It's just like, justice is on my side. Like, I don't care if they have 5,000 attorneys. Like, they lost. It was a fair verdict. Their arguments make no sense. They're not credible. So I don't care. I'm not going to be scared of how many attorneys are on the other side.
Yeah. Well, and by the way, usually a trial judge doesn't like to hear new lawyers coming in and telling them how the trial was not, either they're not doing it, they're saying something that didn't happen, or they didn't do it correctly. I mean, that I've never seen a trial judge who sits back and is happy with somebody trying to come in and say that.
Sure.
Did you did have the trial judge is the one who ruled on it?
Yes.
Okay. Because I know you guys do some weird stuff up there in Philadelphia County. Like, you just show up and get who you get on some cases, or like, I don't know. I had a Philadelphia case and I was like, who's our judge? And they were like, well, it kind of depends.
Yeah. So sometimes, like with discovery issues or motions involving pleadings or summary judgment, yeah, you don't really know what judge you're going to have. But then once you have a trial judge, the trial judge will take care of any post-trial motion.
Got it.
Yeah. Yeah.
It's such a good order. I mean, like, I think my life would be, I think even if I didn't have the money, I'd just have to retire if I got an order that good, just to be like, I'm going out on a high note.
Yeah, that's right. That's right. Well, let's go back and talk about, I mean, so we kind of went a long ways around talking about that they, finally admitted liability. which, by the way, we've talked about many times. It's a strategic, move so that they can basically sit there and say, we're real sorry for what happened. We're taking responsibility, kind of get out, all of those things. And then at the same time, try and say, all we're here is to make sure that, whatever amount you award is a fair amount. And we just, think that it should be something much less than whatever, the greedy plaintiff's lawyer is asking for. But I really liked, I mean, both of your opening and closing, but what I really liked is how you spent time, not only talking about who Eddie was and what he went through, but just talking about this concept that justice means, nothing less than a fair and full accounting of every loss. That's the jury's job, that everything else has already been done, that they've admitted fault. You just need to, take your time and thoroughly, give exactly what the loss was, not more, not less. But talk a little bit about how you developed that theme, and I saw you carried it through not only, in the opening, but through the closing as well.
Sure. It's funny, like it's easy to say in an opening and closing, but now when I have to articulate the reason behind it, it gets a little tougher. I think a large part had to do with my client as well, just waiting so many years, and then to have last minute the hospital, waiting for his day in court, because for 4+ years he's thinking, the hospital, they never admitted any wrongdoing. Like, what do they know that I don't know? Like, we think they screwed up, but they're not owning up to it, and they're dragging things out. They're not offering any real money. They're making us go to trial. Like, okay, this is finally our time for justice. And then they go, waving the white flag here. We're going to admit to fault, and it's just about damages. So maybe the defense, they do want to frame it as, oh, they're greedy plaintiffs, and we're only here because we're not willing to give them a huge amount of money. So they're making it just about dollars and cents, and they really focused on, their medical expert, saying that Eddie's fine, and the life care plan isn't that much. And so, I really just wanted to drive home that, like, look, I get it. It's a hospital. We all like the doctors. We're not asking you to punish anybody. We're not asking for a handout, but this thing of fair compensation, like, that's a lot more than just money. Like, justice really is a real thing, especially, and it's weird, like, for this case, because it really was a case. It's not a case about, disputed liability where people are, fighting it out for who's wrong. It was clearly the hospital that was wrong. And at times it was a little degrading, or no, it was really degrading, having to argue or advocate on my client's behalf when his injuries were so obvious and so immense and so catastrophic. And so I just really wanted to hit home to them, like, hey, you're not just giving him, the money that he's owed. You're telling him that, you have a voice, that you were wronged, and we heard you and we appreciate you. And we're taking in everything that you've been going through, and we're going to respectfully evaluate the case, analyze the case, and give you what we think is fair. So I just really wanted to impress that upon them, that this is more than money. This is about accountability and justice.
Yeah. It was interesting to read in your closing. You could tell that you wanted to make sure that the jury knew that that there was a lot of evidence against them that showed that the doctor and the hospital had messed up, because you talked about how we could have spent, if they hadn't admitted liability last week, we could have spent the next 3 weeks, bringing in all the experts, talk about all the mistakes they made, and we're not here to do that. And then you get into talking about the damages. I wanted to talk a little bit about, I mean, you did I thought a tremendous job just describing not only the amount of pain that Eddie went through all the time, but the different types of pain. And, because when you have an amputated leg, you have residual limb pain, you have phantom limb pain, and then you just have and I guess because the knee has so many nerve endings in it, that just causes an enormous amount of pain. And then, of course, all of these surgeries. But and I think you brought in a physiatrist who worked with amputees in order to help tell the jury all of that. Walk through a little bit about what you did with the pain and how that had really affected his life.
Sure. So, well, I guess first off, my case, I brought out his dad to start. I wanted to focus on the pain that he was experiencing during those 3 weeks at the hospital where he was visiting his son every single day. And he could see his son, stuck to that bed and crying and in so much pain. And the family's crying around him, and the thoughts about saving your leg and then realizing your leg's going to have to be amputated. And then, right after his operation to amputate his leg, I think his dad testified, basically his son saying, "Hey, Dad, I thought they were going to amputate my leg today. It's like, they didn't do it. I still feel my leg." And he's like, "No, son, they did amputate your leg." So that was right then and there. He has this phantom limb pain, which is, like a supernatural, freaky experience where you still feel like your leg is still there, or you can wiggle your toes. And not only is that an uncomfortable sensation, but oftentimes it can be a very painful sensation. And amputees, strangely, there's a correlation where it's not one or the other. It's not residual limb pain or phantom limb pain. Oftentimes you get both types of limb pain. And how you get phantom limb pain, that's not clearly explained in science, but it probably does have a lot to do with just all of your nerve endings. There's so many in the leg and around the knee just get cut. And that's a source of pain that causes neuromas. And then the residual limb pain also is somewhat associated with neuromas, but also in his case, he had basically a bone growth from his residual limb. And it's almost like a deer growing antlers. So that too can also press against the skin. And then his incision was pretty horrific as well. And the incision itself is also a huge source of pain.
Yeah.
So yeah, and I had a great expert, Dr. McNevich. I mean, it's so great when you have, it's an amputation case. All she does basically is work with the amputees, and she's been doing it for decades. So it's her life's work. Like, she really cares. And there's a lot to talk about, though, because there's a lot of injuries or, diagnoses associated with the amputation. And I'm glad I thought it through a little bit, because my direct with her probably could have been 10 hours if I didn't think of streamlining it. And I actually kind of just simply, received a demonstrative that just kind of had bullet points of the diagnosis, bullet points of the prognosis, and just very easily just said, "Okay, what's the next bullet point? Phantom limb pain. Okay, why does he have that? Or can you explain that to us?" And, just went down through each bullet point. And I think in a way the jury was able to digest it.
Right. And I've had cases with a significant amount of pain, and how much it not only, affects them because they're feeling the pain, but also changes in personality, changes in being able to just function, to be even be able to think clearly because you're in so much pain. And it sounded like you developed that as well through some of the family members. And in the closing, you made you sort of basically said that the, Eddie that is dead, and you've got this new Eddie, who has these, really bad mood swings, and, you're just not sure what you're always going to find because he's going through such significant pain. And it sounded like, so his girlfriend, it sounded like they broke up, and she still came and was a witness and testified about some of that.
She did. So, especially with my client being in so much pain and having to deal with the awkwardness of trial, and that, he's there, he wants his justice, but it also must be difficult for, a young, previously healthy, able human to then have to have this whole trial about how he's disabled and all of the things he can't do, and how he's dead, he's a shell of himself and his future is bleak. So I didn't want him to go up on the stand for a very long time and have to explain himself. Plus, again, he might be in pain and that might get him to be agitated or upset. So I very much, wanted his family that saw all this, or his girlfriend that saw all this, that sees the change, speak essentially on his behalf to, what they've seen. So
Did
fortunately, the ex-girlfriend still, she cared very much and she wanted justice for Eddie, so she testified.
and was Eddie in the courtroom the whole time?
Most of the time. I think he was there the whole first day, but then after that, the pain started to get to him. So then it would basically be half days.
Okay. And I guess, what is always important is at some point he gets on the stand and how obviously he did great. I mean, it sounds like the jury must have really connected with him, but talk a little bit about how he did on the stand and how you prepared him for that.
Sure. So he may have only been on the stand for about 10 minutes, give or take. And again, I didn't feel like there was a need to go into these, details, because I think everybody could see that he was in pain. Everybody saw photos of the wounds or heard his family speak. So I basically just kept things pretty simple. Just in a nutshell, how has this changed your life, or what do you want from this, or how has this impacted you with relationships or dealing with your son, or your family, or working, or how has this impacted your dreams? And then just, something, are you in pain right now? Yes. Can you describe your pain? It ebbs and flows, but I'm always in pain. How did you sleep last night? Not well. How do you usually sleep? I never sleep well. Just basic things where the jury knows about it, and they can put two and two together and be like, oh, I can appreciate what that must feel like. So they can really feel, the full extent of his pain without going into, a ton of details.
Right. So I take it, so he had been a CNA, but he was not working since he had his leg amputated.
Right.
Okay. And then I know you talked a lot about his love of cooking, and that he had dreams of opening up a food truck, and then, hopefully turning that someday into a restaurant, and that he basically wasn't able to do that. But I guess what I'm wondering is I mean, I understand that point of it, but my understanding of the defense is that they kind of brought in a like a maybe a functional capacity type person to testify about all the things that they thought he could do. Like you at one point in your closing went through, they said he could be a bar back, they said he could pick up kegs, they said he could do this, things, that. So it's, if there wasn't a claim for lost earning capacity or lost wages, why were they bringing all of that up? Or is it just to show that he's not as disabled as you were making him out to be?
Sure. Well, I mean, we brought it up in our case.
Right.
And again, we weren't seeking any money, lost wages or future wages, but basically it was something he enjoyed doing. So I think it came under the non-economic perspective of like, maybe we take for granted, the purpose we get from having a job or having things to do during the day, putting in a hard day's work and feeling fulfilled from that. And so he lost out on that. And yeah, they brought in an expert who basically said Eddie can do whatever he wants, whenever he wants. And I think that did not sit well with the jury at all. In fact, I remember one juror, I think, commented after the trial that they lost all credibility in the defense within like 1 minute of my cross-examination, because literally right off the bat, I was pretty calm, and I just said, Dr. Sarlo, your first report, you said Eddie can do whatever he wants, work-wise. Is that correct? Yeah, that's correct. It's like, oh, okay. So he can be a fireman? Yeah, he can be a fireman. I'm like, oh, so you can be a fireman, kicking down doors and going into burning buildings? Yeah, he can do that. Oh, can he be a police officer? Yeah, like, so you can be a police officer just like chasing a robber, down the street. Yeah, or he can be a bar back. Yeah, or he can be a construction worker or a carpenter, 100 stories high on a steel beam. Like, yeah, he can do that. So he just kept saying, yes, 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 he can do it. He can do it. He can do it. And meanwhile, 2 days earlier, when my expert's up there and Eddie's walking in front of the jury and we're taking the prosthetic off and talking about all of his pain and all the issues associated with it. And plus it's pretty obvious the guy's missing a leg, so to say he can do whatever he wants in life, and it was ridiculous, frankly. So it's just, they were going too far. It was really a case of where, we kept it very clean. We weren't trying to say that Eddie can't ever do anything ever again, or that he's still in the same state 4 years later than he was 4 years prior. Like, we conceded, we didn't hide that, he went on a vacation once a year for a few days. Not to say he had a great time in the vacation or that he was pain free, but yes, he can do that. Or, it took him several years, but he was able to drive a car, right? And yes, he can drive a car. And so they tried, well, he can drive a car, he can now walk, a lot better than when he used to be able to walk, and he now has this high-tech prosthetic. So, damages really aren't anything. And to me, again, I just thought it was frankly degrading to say, oh, this guy can drive now, so let's not really award him anything. It's not that big a deal that he lost his leg.
Yeah, I noticed you were talking about, I can't remember which expert it would have been, but basically that expert didn't look at photos of Eddie's leg in the hospital, but he did look at like a photo from Facebook of Eddie going to Vegas or something.
Yeah.
And it's just like, when that comes out, what a jury thinks about that.
Yeah, so I didn't confront him on that on cross. I just remembered in his report, it just, listed the medical records, and then it listed Facebook photos of him in Vegas, which I don't know why that was a big aha moment, or they thought it was, because you see a picture of a guy in Vegas with a prosthetic on, but yes, I asked him, because there were actually photos in the chart. It took a while for them to actually produce it of his wounds. And so I go, so that's the only picture you saw? Yes. So in the back of my mind, it's like, okay, I'm going to use that in closing. Like, this guy who's supposed to care about the patient and really know of all the medical stuff, the only photo he's looking at, is a photo of him on Facebook that he was provided. And he also, he got a fair amount of facts wrong. I think he mentioned that I think Eddie had 2 amputations or a revision procedure, which maybe they were planning on that. So there might have been one reference that they may do that, but they never did it. So it's kind of like, this is your expert. He's saying this guy had 2 amputations. He only had 1. And, I think I tripped him up a little bit because he's trying to say Eddie's not in pain. And it's like, okay, let's go through all of his medical records where it says he is in pain.
Right.
Or he's like, oh, Eddie doesn't really fall and things like that. Okay, well, let's go look at the records where it says he falls. And the main thing they were talking about too is they're like, well, this record here says that he's not complaining of back pain, because my expert says, you're walking with a limp, or you're sitting all day, or you're standing weird, you're going to have associated back pain, and it's going to get worse. But it wasn't like a huge part of the case, and that's all they were focusing on was, oh, here, he told his prosthetist that his back pain was fine, which I don't even know if they ever asked him that. And they're just hitting that. So in my closing, I'm just like, I don't know if Temple knows this, but like, we're here because this guy lost his leg. Like, all they're talking about is the back. Like, what are they doing?
Yeah.
Plus, it's like it's a little bit hard to focus on your back when you're having 10 out of 10 leg pain every day. Like, you might not be noticing your back that much.
Exactly.
Yeah.
Jordan, I wanted to ask you if you said that you did get to talk to the jury, and that they mentioned the fact that they one of the experts lost credibility on your cross. Anything else that the jury told you about the trial that really swayed them or was effective with them?
So actually, I really didn't get a chance to talk to them for too long. I showed up a bit too late, and only a few of them were still there. But that was one comment that resonated with me. Another comment too, I think someone made, was they could tell that I really cared about my client, and they felt that I was compassionate too, because there are other, parties or witnesses that were getting hostile, and I was trying to keep it calm for the most part. And even when, some of the fact witness testimony, it was powerful in that courtroom to just, when somebody's saying like, my son is dead,
Right.
that's not like, this is not the person that, was my son. It was just really, powerful. And I would just be like, whoa, like I would have to take a second and just like, okay, I need to just let this be said, and let people take it in, because it's just so powerful. And it was emotional for me too. And I've been a part of this case for years. So the fact that it was making me emotional, it was very raw. It was very powerful, some of that testimony. But yeah, so I got a little sidetracked there. But I think some of the jurors at least noticed and could appreciate that I very much did care for my client. I wanted him to get justice, and we were keeping it real. We were being authentic. We weren't exaggerating things. All we really wanted was what he was due.
Right.
Yeah.
Right.
I thought it was really effective too, how you pointed out, I think it was in your closing, like, look, they're acting like they're apologizing to Eddie, but they've never looked at him. They're looking at you when they're saying that they're sorry about what happened, which happens a lot, right? They, if you do get these sort of concessions about things, a lot of times they're looking at the jury, because those are the only people they care about in the room at that point. And I thought it was really smart to highlight that, whether that was a strategic decision by you or just a genuine gut reaction because you're sitting next to your client you care about and they're not looking at him. I thought that was very striking. I imagine that resonated a lot with the jury.
Yeah, I don't know if I planned to say that or not. I can't remember, but I mean, it really was disappointing, just in all the ways that they were, we accept fault, we're the good guys, but then
Right.
every single turn to just kind of, try to screw Eddie, like they were trying it. Like life expectancy, oh, he doesn't have the life expectancy our experts say. We need to take 5 years off of that, or just literally every single which way they can minimize what he's going through. And then, yeah, the apology was a degrading apology. If you're going to apologize for somebody losing their leg, at least have the decency to look at the party, or even if it's just a glance for a split second. But it was literally just staring right at the jury. Oh, we're really sorry for what happened to Mr. Parks.
Yeah.
And and I remember, because I guess maybe I was trying to prove the point, and just, did you notice that apology? And I did. They weren't even looking at Eddie. And then I actually turned around and I looked at the lawyer and the doctor, and I said that apology was unacceptable. And then still, even in the closing, though, I think he apologized again. And again, he just looked right at the jury.
Right. Yeah, exactly.
Yeah.
And going back to the life expectancy for 1 second, where you said they had taken 5 years or given him a life expectancy, it was 5 years less than I think what your expert had. You caught a slip of the tongue, but apparently they had said, let's lop off 5 years. And then you of course brought that up the way they refer to, like, let's just lop 5 years off of Eddie's life. He's not going to live those last 5 years. It's just things like that just completely undermine what they're doing.
Yeah.
Yeah. You were like they lopped
that.
off his leg. I was like,
Right.
oh,
Yeah, exactly.
rough. Yeah.
Well, Jordan, this has been just a really good, thank you for going through this with us. I was, just can't help wondering, since you did such a great job, got a great recovery, how is Eddie doing nowadays?
Certain things won't change.
Yeah.
But I'd like to think that, knowing that he got justice finally, that he has some sense of closure. and then the money I hope will help him in certain aspects of his life.
Yeah. Yeah. The one thing I saw, I think in one of the articles about when they were talking about the M-Care, and their motions there, that Temple University Hospital has at least claimed that they're going to change their litigation strategy after this. You have any idea what they're going to change about it?
I don't want to speculate too much or go off of here
Right.
what's been said, but apparently there's been an overhaul. There's a new general counsel over at Temple Health, and he got some other law firms involved, and I hope that the reinvented strategy is to just do what's right. And if you are wrong, you are at fault, then just offer a fair and reasonable amount. And because we'll never really know if this case could have been settled, because they never offered. I mean, they offered $3 million. Some people may take $3 million. It's always a possibility. But, to give me a call and say, hey, we're going to admit liability, and then also $3 million is our final offer.
Yeah.
And we have a $6 million, for future meds alone, and their own plan, I think, was like $2 million. It's like, what are we doing here?
Right.
But it seems like they have an interest in maybe evaluating cases earlier or seeing if cases are able to resolve. But we'll see. Again, I try not to speculate on what the defense bar is doing or thinking, but hopefully it'll help victims of medical malpractice in Philly.
Yeah. Yeah. Well, Jordan, before we let you go, is there anything else about let me remind everybody, we've been talking about the Parks versus Temple University Hospital case that was tried in Philadelphia last year in May of 2023 and resulted in a $30.3 million judgment. Is there anything that you'd like to make sure our listeners know that we haven't had a chance to talk about that case?
I guess generally, especially for maybe some younger trial lawyers, or frankly, any trial lawyer who needs to hear this. I started my firm almost 5 years ago, and this was actually one of the first cases I got, or definitely first medical malpractice case I got. And I've been practicing, I was practicing maybe 4 years, give or take, when I started my own firm. And, I'm telling people I do catastrophic injury or I do med mal. And I'm sure a lot of people maybe looked at me weird or saying, oh, he's not really going to be doing that, or maybe he can't do that. And I remember after the verdict, an older partner at a defense firm is like, what you did is, should be impossible. Like, you can't be a small firm and go up against big firms and try a case by yourself and get a really good result. I just want to say, like, when I started my firm 5 years ago, if I had to try this case, the next day or a week from now, no, it probably would not go well, right? But I think as trial lawyers, especially younger trial lawyers, if you have the confidence that, okay, I might not be where I need to be, but if I work my tail off and work as hard as I can and constantly want to learn and do inspiring work, like, you can get to that place. Yeah. So I guess I don't know if I gambled on myself, but like, I personally always thought I could get this result. Like, everybody says, oh, you got this, like, what's the secret? Or were you so surprised? And really, to me, I thought it was quite a fair verdict, and it was a number I was expecting. I honestly just kind of felt relieved that my client got a just result and that I didn't screw it up when the verdict came down. But maybe I'm rambling a little bit, but maybe some words of inspiration for attorneys who are wondering if they can do it. If you're willing to put the work in, you can.
Yeah. No, absolutely. I mean, I agree 100%. I mean, I think I've told this story before, but it really does come down to, how hard you work and how hard you prepare and your passion for your cases. But I'll never forget the first, big trial I had against Ford Motor Company. And I had read all their openings. I had read all their closings. I knew how they were going to argue this. And and I give my opening statement and I literally tell the jury, this is what you're going to hear from Ford and this is why it doesn't make sense. And, and I'm thinking, these guys are, seasoned trial lawyers. I mean, they've tried a bunch of cases. There's no way they're going to get up there and just say exactly what they've said before, because I just told the jury they're going to do that. And then they got up there and they said exactly what I told them they were going to say. And it just made me think, like, the fact that somebody's tried a bunch of cases doesn't necessarily mean that, they're any better than anybody else. And if you're willing to put in the hard work and kind of think about things in a new way, I mean, a lot of people can do this job. A lot of it comes down to hard work and passion and just taking the time to think about how you're going to do stuff. But no, this is a great result. Great work. And it's been really nice to talk to you. Let me remind everybody, we've been talking to Jordan Strokovsky. Jordan is at Strokovsky LLC, and you can look up Jordan at actionafterinjury.com, where you can see his valedictorian speech, which was very good. I really enjoyed watching it, and it's not too long. It was one of those speeches that was, it was motivating and inspiring, and then you sat down, and I thought it was perfect. So anyways, it's been really nice talking to you, Jordan.
Thank you. It's been an absolute honor speaking with both of you. And I'm really floored that you all invited me to come on the show.
No. Well, this is great work, great case. And believe me, I mean, I'm not kidding. I don't think I've heard of any medical malpractice lawyer tell me that they went in and tried and admitted liability. I mean, it's very rare. I'm sure there's a few out there, but it does not happen a lot.
Yeah.
It only comes after a lot of hard work. I can say that for sure.